The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
Welcome to Condo Craze and HOAs. Yes, on a Sunday morning, Karen Curtis with attorney Eric Glazer. He is board certified in community association law. And we're thrilled to be here with you. Sorry, we're a little bit late. Had some technical difficulties, but we're back in our old slot today at 11 a.m. And we are on the Condo Craze and HOAs channel and YouTube, made possible by our fantastic sponsors who truly offer you the best services in South Florida, including our diamond sponsor, Best Roofing. So Karen, me, I just read my own name. I'm here with Eric Glazer. He has offices in Hollywood and in Orlando. Oh, hi. And we'd love to get the phone lines going early on our YouTube chat as well, answering all your condo and HOA questions, no matter where you are in the state. So give us a call right here in the studio. The number is 717-GLAZER-8. That's 717-452-9378. And you can visit us, of course, on the Condo Craze and HOAs channel, on the YouTube channel, which you're on now, obviously, and ask your question in the chat box.
Hey, feels great to be back on Sunday mornings. This is where, this is the sweet spot, I think. We belong right here.
Yeah.
So thanks for tuning in on Sunday, everybody. And of course, don't forget to subscribe to two things. Number one, of course, the Condo Craze and HOAs channel on YouTube. You don't just have to watch the show live. You can watch it at your convenience anytime. Big library of episodes now. And of course, join our email list at condocrazeandhoas.com. By joining each week, you can get announcements about the show, our seminars, updates on the law, and a bunch more. And we're on social media, aren't we?
Oh, we're on the socials. Yes. Yeah. So we're you can follow us on Facebook, TikTok, Apple, Spotify, and X.
All right. We also do a blog every Monday morning for like 15 years now. It's at hoa-condoblog.com, hoa-condoblog.com. This week's topic, the annual meeting. What can go wrong? Right? All right. So many of the new laws this year are focused on actually charging people with a crime. Right? Whether it be board members, whether it be managers. And if you think that that doesn't happen, like tampering with the election process, let me tell you, it does. And we're going to talk about a case that I won over 20 years ago. And you tell me what you think. Leave a comment, maybe. So I represented 5 plaintiffs who wanted to run for the board in their condo. The name of the condo is in Miami. It's called International Park Condominium 2. We filed an arbitration case in that condo. Association failed to provide my clients with notice of an election not less than 60 days before the election. And because they weren't given notice, they didn't have the right.
Was there any notice at all?
Else, that's what you see. My clients, as you'll see, the only one given proper notice, them candidate to do so because they of the election.
So how did this case turn out?
Interesting case. So the arbitrator found that the association didn't mail or deliver notice to within 60 days of the election, specifically to my clients who wanted to run for the board. And the question during the arbitration trial was whether this was done as a result of just inadvertence or was this intentional?
Well, I mean, you've obviously, specificity.
Yeah.
but just so did the old board roll over, or were new people elected?
The old board members rolled over. They got elected again. Let's just put it that way.
My God.
Yeah.
All right. So now, how did the arbitration case work? How do they work? I know you do arbitration, or your mediation.
I'm mediation.
Yeah.
Right. Exactly.
And is the arbitrator live in front of the parties by Zoom or on the phone?
So we did this case, like I said, over about 20 years ago. Zoom didn't even exist, so this was totally by phone. And here the issue was, if the association deliberately didn't provide the unit owners with notice, in order to prevent them from running for the board, from seeking candidacy, a new election would be required. And believe it or not, that's a significant remedy. It's hard to have a new election
Right.
ordered by an arbitrator. But for some background here, my clients testified that they previously tried to recall the board members. So there was animosity between my clients and the current board. And one of my clients testified that she doesn't get along with the president. They have a problem between the two of them. So it was, that sets the tone for what's about to come during the trial.
And I see that the president testified that he was not involved in sending out notice of the election and that he did not tell the management company not to send notice to certain
Right, that's how the president of the association testified. Totally not believable. Okay, no credibility
I
whatsoever.
never said to
Right.
them.
The arbitrator found that the association mailed a copy of the notice deliberately to an incorrect address. The association mailed another copy to an incorrect address. The association didn't mail the 60-day notice to another plaintiff. Another copy was mailed to a name that the plaintiff doesn't use. Another copy of the notice was mailed to a Eugenio Ang, A-N-G, and it was supposed to be mailed to Mr. Angulo. There's no such name as
So
Ang.
they can say that they mailed them.
Yeah, they put something in the mail for some of them, but to the wrong
But
people that don't exist.
deliberately, yeah.
Right, and the cross-examination of these people were fun. You know, I saw their list and didn't match any of the names
is
of
so
my
amazing.
clients. Yeah, it was pretty something. And finally, one of the plaintiffs, the address of one of my clients' units, Mr. Escalante, who was on the list, they sent it to an incorrect address, and this just went on and on. I was able to prove this in cross-examination that my clients, specifically my clients, were the ones that everything went wrong. They didn't have the right address, they didn't have the right names, etc. So.
Holy smokes. So I'm sure the management company had some kind of defense. What was it?
What do you think? These were honest mistakes. We didn't mean anything. I don't know how this happened. And of course, but here's what the arbitrator held in the end. Interesting. The association failed to assert a credible reason as to why the individuals who didn't receive notice just happened to be the four individuals whom the association or the management company have a contentious relationship with, right? Is it a coincidence? The association failed to explain why it used a nickname and a shortened name for some individuals that they've never used before. They just made up a nickname. And the arbitrators said simply the explanations that the board was given and the management company was given, not convincing at all. And the most logical conclusion, I'm telling you, you won't find another case that says this. The most logical conclusion based upon the evidence before the arbitrator is that the association intentionally failed to send the first notice of the election to several unit owners, thereby depriving those individuals of the opportunity to seek an election as a board member. Think about what we just said.
That should be criminal.
It would be today.
It would be today.
Okay, that's the amazing part. It would definitely be today if this action took place, and instead of being 20 years ago.
And it would be criminal for the board members and the management company?
Yeah, if they both conspired, no question about
conspiracy.
it. Yes. Yep.
Okay, so what was the relief that the arbitrator ordered?
So after hearing all this testimony, the arbitrator held that the relief that we requested, a new election, it's an extraordinary measure. Yet in light of the facts of this case, the board intentionally failed to provide notice to at least 6 owners not less than 60 days prior to the election and had provided no credible evidence for doing so, thereby depriving those owners of the right to run for the election. The election was found to be invalid, and a new election is the only remedy that will suffice. And I can tell you, go look it up. It's hard to have a case where you prove that an election was deliberately thrown, but we proved one.
So arbitration is binding?
It's non-binding, but you can always take an appeal to court.
And they did not?
And that situation, no.
Okay.
They did not. They didn't go
and
to
then
court.
they held a new election, and what happened?
Yeah, I believe my clients won. So long ago, yeah.
Oh,
but,
come on, that's the whole
yeah,
thing.
but you asked a question about what would happen if it was today.
Yeah.
And if it happened today, everybody here could be charged with a first-degree misdemeanor.
Oh, it's a misdemeanor.
So when the legislature, made these new laws and boards were freaking out, how can you do it? These things happen. The good guys suffer for the bad guys. So, these laws were designed for the bad guys. And yes, the bad guys are out there. Today it would be a crime. And here's what you don't know about the opinion. Here's where it gets really juicy. One of my clients had their car blown up. Blown up. They looked out the window and their car was on fire. Okay? Another client.
Criminal mischief.
You think so, or certainly criminal mischief, and maybe other crimes.
Attempted murder.
I don't know.
I mean,
if they weren't in the car, but another client. How about this
Arson.
one? Somebody loosened up the lug nuts on their tire, so they're driving the car and the tire goes flying off. That's what you don't. Yeah, that's what you don't know about this case. Just how crazy, how bad it can be. So if you don't think elections can be nasty and there's a reason for these new laws, you're wrong. The elections can get very nasty.
So this was during arbitration, before arbitration?
This was before we went to arbitration. I mean,
that's probably was the impetus for them to come to you and say, look, they're trying to kill me.
Exactly. They thought that these actions are going to scare my clients away. No, it just made them tougher. But now that you heard out there about maybe one of the worst boards in history, right? When you call in today, I expect some of you to say, especially in light of the fact that this is a upcoming Thanksgiving weekend, right? So Thanksgiving's ahead of us. I certainly would like some of you to call in and say, I'm thankful that my board of directors does what it does. I will tell you this, I'm thankful for my board where I live. No question about it.
Me too, I'm thankful for mine.
I appreciate it.
We're our fully funded reserves, everything's
Fantastic.
good.
And everybody leaves me alone for 20 years. No one asked me a question. So yes, I'm thankful for them. So let's hear what our viewers have to say. You can call in here at the studio, 717-GLAZER-8. That's 717-452-9378. Or drop us a comment or a question in the chat box on YouTube. We'll be back right after this.
There are very large management companies and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
So Eric just told me the story. Can we talk about Brandon for a second?
My son started a job with a management company. He's doing great. Brandon with Sunrise Management.
He's in college at FAU.
He's in college at FAU so far, like basically all A's. He's doing good, following in Dad's footsteps. But he had a meeting with an HOA. It's his first time he's going to meet with the HOA. So I said, you know what, I'll show him how to do some research, what you should be looking for. So when you get there, you can talk intelligently. He knew about the fact that documents expire after 30 years if not preserved. So we do a search on this community to see when their documents are about to expire. 3 weeks. We were in...
They must have been like,
They were in year 29, week 49. If you can
and
believe
when
that.
an HOA expires, you're no longer an HOA.
That's correct. You're gone. Now you have to revitalize
He
them.
like saved the day.
Saved the day. Correct.
And got the job.
Yes, correct. Absolutely. So interesting story. So again, to HOA members, check your docs.
Go Brandon. Wait, how does that dance go? I can't do the dance.
Oh, the Trump dance. I don't know. I don't dance on camera.
There's too many moving parts.
But the athletes are doing it now. It's great.
I know.
All right. Let's go to Norm Goldstein. He'll ask a question in the chat box. Norm was first this morning. It says you need the Florida statute says you need a 14-day notice for rule change. The association says that only applies to changes in unit-specific rules. What say you? So I called up the statute. This is what it actually says, Norman. Written notice of a meeting at which non-emergency special assessments or an amendment to rules regarding unit use. An amendment to rules regarding unit use to be considered has to be mailed, delivered, or electronically transmitted 14 days in advance. Okay, so that should answer your question. Rules regarding unit use. Okay, who else writes in here?
Our pool hasn't functioned for 2+ years and has been closed by the health department. It is dark green and stinks. But wait, there's more.
Pool's a little dirty, so this person has to make a whole big deal about it.
Oh, man.
So what, 2.5 years? You could swim in that. That's
No.
gonna happen, right? So what should you
It's
do?
like Lake Erie.
Yeah. You should absolutely file a complaint. They won't fix it. Yeah, you should file a complaint with the DB.
Well, it's a health hazard.
Yeah. I can tell you that unquestionably they have a duty, they have an obligation to maintain the common elements. Statute couldn't be clearer. I'm sure their documents say it as well.
You're paying for
You're
it.
paying for it. And if you're not maintaining the common elements, yes, you don't have to sit back and watch as your pool never gets placed in normal condition again. You can file an arbitration action, or in an HOA, you might be able to take them to pre-suit arbitration.
Sounds like they
Pre-suit
haven't.
mediation, I should say.
They probably haven't even had an election there. They probably
Right. If you
haven't.
let that happen, there's other things that they're not doing right. I
yes,
agree with
the
you
pool is
100%.
just a symptom.
Exactly, agree 100%. But no, you don't have to sit back and take it. Do something about it, okay? You may need to have to contact an attorney, but yes, you should not be allowed to keep the pool in that condition when, obviously in South Florida, we need swimming pools. And you're like you said, we're paying for
How
it.
about there's gators in there?
Could be. I don't know. Who knows? I know I'm not going into.
There's your number right there, right?
First call of the day.
Let's see. We have a caller from Hallandale, I believe. If you hear a beep.
You might hear a delay here, or turned on your computer. We're ready for you to go.
Hollandale, are you there?
Good
Oh.
morning, Eric. Good morning, Karen.
Good morning.
No, I'm fine. In your absolutely fascinating case, Eric, the one that you recounted in the beginning, who paid the attorney's fees, and was there any monetary relief for the owners since they suffered health issues? Obviously, it was stress, and they wasted a lot of their time. How did that go? That was not my question. This is just follow-up.
So, in that case, remember, it wasn't a suit in civil court.
Right,
So it's
right.
not
it
like
was
we were
arbitration.
suing for damages. You had to bring that election issue in arbitration. If they wanted to potentially pursue claims for damages, they could have potentially done that. And remember, we didn't know who blew up the car. We didn't know who took the lug nuts off the car. So it'll be difficult to prove.
I
But
wonder.
that the answer to your question is yes. Remember, we sued the association on behalf of individuals, and yes, the association had to pay the attorney's fees in the end for the petitioners in that case. Good question.
That means the owners
So my
paid.
actual question is, during the board of directors meeting, let's say a resolution or a motion was adopted, does it become effective immediately after the vote or after the minutes are approved?
Immediately after the vote. Yeah, I mean, you can have a resolution passed and the minutes just sit and never get made up. A lot of associations, as you know, they don't even take minutes. So once the resolution is passed by the board, that's when it becomes effective. Okay?
Shouldn't the
May
minutes
I
be up on the
squeeze in
website?
Another little.
Yeah, go ahead.
Okay. Material alterations, when they're clearly violated by the board and the management, what is the proper way for a condo to proceed?
Oh, this is a good one. I wrote portions of that statute based upon a bad ruling by a Dade County judge. And while the legislature was in session, I had them amend the statute to overdo her terrible decision. So what's your question? What do you do about it if they're violating it? So what you must
Yes, they're
do.
violated in the condo. What's the process?
So,
What's
for
the legal
example, let's say you're living in a white building. The building's painted white, and without a vote, the board paints the building tan or blue or whatever it may be. What do you do about it? You can sue and have the association put it back to the color it was. And if we look at the statute, the portion that I added to the statute was the very last sentence, and it says, the vote must be taken before the material alterations are commenced. So if that is broken, right, and they take it after, sorry, too late, you got to put it back to the condition it was in. So it's a no-joke
Does it go
statute.
to me-
But the boards
Does it
have,
go to mediation, arbitration,
Arbitration.
and court, or just
That needs to be dealt with by an arbitrator. And arbitrators, you make those type of decisions all day long. That the material alteration was made without the vote of the community, therefore put it back. So how embarrassing is it for an association to maybe spend $100,000
It's a
on
lot
a
of
paint job?
painting.
Yeah, right. And it could be for nothing. So I say this all the time, boards, if you're not sure, if you think it might possibly be a material alteration rather than a repair, you better get a vote of the community. Ask for advice. Get some legal advice.
Right.
Okay, bottom line.
Right.
Might wind up saving the association a lot of money.
because there's a fine
And a
line.
follow-up, when the board does it deliberately and repeatedly because nobody objects, how is that handled?
You got it. The bottom line is you have to go in front of an arbitrator. Now, if you say they do it deliberately and repeatedly, if they did that within the statute of limitations period, you could sue for all of that. All of it.
Agreed.
If they have done it within the last, let's say, 4 years, right? You can file an arbitration action to have them put everything back that was illegally done within the last 4 years.
Oh, Lord.
Yes. So, you know, there's potentially a lot that you could sue for if the board simply didn't get the vote. But we got to keep moving on, Julie. I really appreciate the phone call. Rob, you had a question or a comment?
Yeah, I just noticed boards have discretion with routine maintenance that sometimes falls under what
Right.
would be considered
Okay, so
material
routine
alteration.
maintenance, that's one thing, you know, to just take care of things. Put a fresh painted coat on the building, that would be routine maintenance, right?
Yeah.
With certain repairs they can make without a board vote. As long as when you say repairs, you're not changing the look of it, you're just repairing something.
Like carpet to tile, tile to
Okay,
carpet.
that's where it becomes a material alteration, right? You want to replace carpeting with carpeting, it's basically a repair. But when you're replacing it and you're changing the color, no, that's when it becomes a material alteration. It could be a lot of things. It could be changing the colors of the carpeting, the interior look in the main lobby, right? Totally changing the theme, the colors could be absolutely considered a material alteration.
So you can go
and not a
carpet to
repair.
carpet, but if you change the color,
That's it's material alteration. So
What if they don't have the carpet anymore?
you get it as close as you can. Now, there's other cases that say a board shouldn't be prohibited from using the latest in technology.
Okay.
So, for example, you have certain lighting in the community, right? But now they've come out with solar lighting. They could save the association money. Is it a material change to go from electric hardwire to solar lighting? No, because there's cases out there that say boards should be allowed to engage in the newest forms of technology.
but cameras are.
Cameras considered a material alteration.
Yeah.
Yes. So, you know, I know there's all these, and yet a fence around the entire community, not considered a material alteration. So the bottom line.
And you can't put up your own fence.
No, you cannot.
You cannot.
So the bottom line is ask your counsel before you do anything. Yes, Rob, there's a fine line between repairs and potentially material alteration. Okay? Who we got next?
Let's go to Robin from Margate.
Hey, Robin.
Hi. Hi, Eric. How are you?
How are you?
I
How
live
can
in
we
a
help?
condo. Good. I live in a condo building. I have a storage unit there also. They stopped sending out bills for yearly rentals. I don't keep track, and now they're threatening to take away my unit for non-payment since 2022. The manager emailed me last week, and I will quote what she said in the email. I have noted that you did come to me in 2023 asking about your storage unit lease and payment, and I responded that getting leases and payment up to date were in the works, end quote. She never got back to me, never sent anyone a bill or myself for the 35 storage units in the building. What should I do?
You should pay what they say you owe, as long as they're not tacking on, you know, interest, attorney's fees, late charges, anything like that. I would. Are they asking you for those?
Yes.
Oh.
Well, I would see if you can negotiate the late fees and the interest. Like, you know, and this happens a lot.
Oh.
Let me just hang out 1 second.
How come? Well, they should be billing people, for their units.
The association is never under an obligation to bill.
Oh,
But you are under an
ding.
obligation to pay. Okay? That's a very common defense, and it always loses. But I never got a bill.
Really?
Well, if you would have come to the budget meeting, you would have known what the monthly payments were.
So the
right?
association shouldn't be under the responsibility of sending you an election notice.
Well, that's different. But if you
They
look
don't
at the
have to send you a
statute,
bill.
that's there. But there's nothing in the statutes. If you read them from cover to cover, there's not a word that says the association must send out a bill in order for the unit owners to pay. It doesn't say a word like that. But you have an obligation to pay.
Well, there you go.
And you can look. That's under Florida Statute 718.116.
Look at you.
Yeah, that's
Fun fact.
very common statute that you get sued under when you fail to pay, 718.116. So be careful, okay?
Pay it
I'm
and
telling
then argue it.
Right,
Yeah.
pay it and then argue.
Yeah.
How many times have we said that over the years?
Otherwise, they
Michelle?
can really get nasty.
Yeah, exactly. All right, so that's the best advice of the day. Trust me. First two callers have not said, I'm thankful for my board. Maybe the third will, Rob. What do you say? Who do we got?
Let's see. Let's go to Drew from Vero Beach.
Hey, Drew.
I'm sorry, I can't say something positive about my board, unfortunately. They are doing some good things, but others are, which is the reason for my call. I have two quick questions. Our community is comprised of villas which are up front close to the gate and single-family homes in the back, which happens to be where the board members live. These are electronically controlled gates that from 6 to 6, but there's also a walk-in gate and there's no lock on it. Last February, what happened is the villa closest to the gate, there was a walk-in, somebody walked in and they were disoriented and knocked on the door at 11 o'clock, startling them. The board at the time, which I was on, actually took advice from the management company and had them start to do research on getting an electronic lock, for the pedestrian walk-in gate. Well, the new board comes in and they're blowing us off, and saying, well, it's on the list, everything else more important, and they actually put in security cameras so they can catch somebody that comes in after the fact. But I actually sent an email to the board stating that this was a safety issue. And I actually took and used a URL from one of your podcasts where you basically illuminate that unresolved safety issues can result in lawsuits against the board members themselves. So we're at a standstill here where they just don't want to respond. My question is, can I go door to door and get a petition going and send it to the HOA attorney to try to force them to do something here?
Yeah, you can certainly get a petition going, forcing that issue onto an agenda, right? Once you get, I think the number is 20% of the people in the community to sign a petition that says, I want this topic on the agenda for our next meeting, the board has to put it on the agenda for the next meeting. And I'll tell you what makes this very serious, quite frankly, is that you are a former board member who knew about this potential safety issue, not potentially, a real safety issue.
Right.
And you put the current board on notice and you're saying, hey, you better do something.
And that didn't do anything.
To stop this to stop this gate that's wide open.
Happen,
right.
Oh.
Something can happen. Something did happen.
Yeah.
And let me tell you, if I'm representing the plaintiff in that case, your email becomes almost like the bombshell. That they were even advised by a prior board, hey, you better do something about this because let me tell you what happened while we were on the board. That quite frankly may be a deadly form of communication that they got from you because if they know people can now walk in and walk out of your community, knock on doors, and that anything could probably happen, they better spend a few bucks and figure out a way to close that gate.
Well, does the email suffice for a certified letter?
Oh, absolutely. As long as one board member can prove he sent it to the current board and they've got it. They knew about what this old board member's saying. Yeah, I think it becomes pretty serious at that point.
Okay.
Would it make the officers
Well, it actually was on the agenda of the last meeting. Again, they brought it up, and they basically just sitting there saying they just are dismissing that it's an urgent safety issue that has to be addressed. So that's and it's like they're just stupid. I mean, why wouldn't you?
Yeah.
It's not going to be a huge amount of money.
Right. I don't think it would be either. Why can't you make it an electronic gate and give everybody a fob that they have to walk around with? But Rob, you asked a good question. Could a person on the board be potentially liable? Personally, yes. One of the exceptions, again, if you're on a board, you're immune. Don't worry about it. Just as long as you act in good faith.
But
One
you
of the
know about it.
exceptions to that is safety, when you deliberately show a disregard for the
And Ted Bundy goes through
welfare
the
and
gate
safety
and he
of-
kills 5 people.
And that's what's happening here. There's an intentional disregard for the safety. Absolutely, it could potentially be a liability on a board member individually.
All
because they
the
were
board
put on
members
notice.
or just
yes, all the
officers?
board members.
And that's
Yes.
civilly and criminally.
Maybe not criminally, but
Okay,
certainly
civilly.
civilly. Certainly civilly. Hey, we're running a little late for our first break. Good phone calls today.
Yeah.
Sounds great. Let's take our first break. Keep the calls coming, 717-452-9378, or drop us a question on chat box on YouTube. Be right back.
For mitigation after a catastrophic event, building restoration, repair and remediation consulting, or Senate Bill 4D inspections, please visit rimkiss.com.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion. Or call us directly at 561-853-5463.
Welcome back to Condo Craze and HOAs here on our YouTube channel. This is the second half of the show. We're having some interesting questions pop up in our chat box. One of them was HOA townhome pool area with cameras with two-way audio. The audio does not record, but live listening is capable. Is this against the two-way consent law?
Yeah, if it is, as if the board is not disclosing that you're being listened to. It's illegal to do that.
That
with
is
somebody else.
creepy.
Yep. That's exactly what the law is in Florida.
How do you know
Florida's
they're
one of those
not
states.
recording it?
Florida's one of those states that requires both parties to
They're
consent.
listening.
In certain other states, you only need the consent of one of the parties to record. So Florida
right.
is different. Okay, let's go back to the board again. Richard, look at this one. This is discouraging. My CAM discouraged other board members from taking a 4-hour class, saying only 2 hours is required by law. That's wrong, and that's why community association managers should not be advising anybody on what the law is. And it's easier online saying just log in and don't worry about watching. Shameful. I agree that that's shameful. Absolutely, it's a terrible thing for a manager to say to its board of directors, maybe there's a thought process out there that maybe certain companies out there, maybe they want you to remain dumb.
They do.
Because the dumber you are, the more you got to
can't
rely
bother
on
them.
them.
Right.
So I think it's wrong, terribly wrong, and not putting down the DBPR. They've tried to come out with a course, but it's one of those courses where, believe it or not, you could sit down, put it all up on your computer, and basically walk away for a couple of hours and finishes and come back. And,
You actually have, in addition to residents, you have, board members, you have residents take your course.
All the time.
And they're not low information, let me tell you.
No, and a lot of times they walk away with a feeling that, wow, I didn't know there was so much to know. And they realize just how difficult the job of a board member is.
Yeah.
So
it's actually a good thing.
Yeah, it is a good thing. I'm very much in favor of it, as you know. How about we go back to the phones, Rob?
Let's see. We have our next caller would be Larry from Miami. Structure.
1 second before we go to Larry, just want to get back to that 1 second. So I taught the class last week.
Yeah. November 13th.
I couldn't make it to Orlando, so I taught it online.
Okay.
I timed myself without taking a break, without any break whatsoever, 3 hours and 53 minutes without shutting up, right? My wife would have left me if I did that, right? But these people did not leave me. You know what? Again, what comments we were getting? We wish it was a whole day.
Wow.
So that manager who tells you, no, just walk away, Absolutely shameful. Let's
Bad
find out
idea.
who it is.
Yeah,
Let's
yeah,
find out.
yeah.
Let's ask that. Let's call them up. Let's get them online and find out why they said that.
Yeah.
Back to Larry.
Larry, you live.
Hello?
Yes, Larry. How are
Hi,
you?
Larry.
Hello?
Hello, Larry. Wasn't that a show? Hello, Larry.
Hello,
Barry.
Larry. Oh, it's Barry.
This is Barry.
Oh, Barry. I'm sorry. How are you, Barry?
Yeah, last week I was Gary. This week I'm Larry.
We're getting
Barry.
closer, though. We're getting
You're
closer.
like the Three Stooges
I
in
think,
one.
I think next week we're going to hit it right on the
You
head.
call him Mo.
Okay.
What's that,
Eric,
Barry?
you said that the 4-hour, that a 2-hour course isn't good enough. Why did you say that?
Well, on the condominium law, it's very clear.
Well,
that
they didn't say it was a condominium.
That's true.
They just said
Okay.
the CAM said you couldn't do it.
The CAM.
You don't know if it's a condominium or an HOA.
That's true. I'm assumed it was a condo. Under the
You can't assume
HOA
that.
statute, it's very unclear. It was a terribly worded statute this time. It doesn't actually say even how long it has to be. And yes, it doesn't say what happens with the people that were already on the board. Well, when do they have to take this class? So, Barry, I agree with you. Poorly worded statute that I believe you're working with a senator or a member of the House working to fix the ambiguity in this statute.
Right.
Yeah, there's no
Right.
question it
Yeah.
needs it.
Law firms are giving HOA board certification courses that are 2 hours long.
Okay, listen.
HOA.
I spoke for 4 and I could have spoke for 40. That's all I can say. You know, I could have turned it into a week-long class, but I guess to each his own. Some people would just like to say they showed up and they walked out as fast as they can, and there are those that actually care about learning everything and would love to sit there for 40 hours.
Yeah.
So, but Barry is right. The HOA portion of the statute, very confusing, very ambiguous. Nobody knows as to whether or not they have to take it if they were already on the board. There's differing opinions among attorneys whether or not they have to take. What was the intent of that statute? That the people who are on the board have to take a new 4-hour class within 1 year? It could be argued that was the intent.
But you don't have to worry about a building falling down in an HOA.
A little different, correct. I would agree with that. That's exactly right. But to learn the condo laws, to me, at this stage, right now, perhaps more important than the condo laws being more important than the HOA laws. I would agree with that. There's just so much to know if you're on a condo. Barry, you know what's? Look at what Karen and I just said. So I think Karen and I both agree that because of all the new changes in the law, the fact that a building could collapse, and now we have mandatory reserves, we have mandatory inspections, mandatory repairs, all of this for a condo. Yet, let's talk about even further how the HOA statute is screwed up. Continuing education for HOA members is 4 hours a year or 8 hours a year if you're above 2,500 units. Far more than the 1 hour mandatory education for condos. Barry, can you explain that? Because that makes zero sense to me as well.
It's only 1 hour.
They should be the same. There's too many laws that are different between condos and HOAs. And to have these confusing rules that have one set of mandatory board education for condos that's completely different than HOAs doesn't seem to make sense.
Agreed.
But I can only add that the reason for a 2-hour or the reason why a lot of law firms are only giving 2 hours for the HOAs is their course does not have to cover SIRS. It doesn't have to cover milestone inspections. So they have a lot less that are required to cover, and that's why they're doing it in 2 hours.
Right, and the way I teach the class, and I think that people enjoy it very much so, we take a topic and we show the difference between how an HOA teaches that topic as opposed to how a condo treats the topic. And that raises more questions. And it becomes, at least to me, when I teach it that way, the people are very much involved, ask a ton of questions. And I actually prefer to teach it both at the same time, to compare and contrast. The smart people that attend love that.
Yeah,
so,
right.
Barry, like always, I really appreciate your help. Number one, when it comes to correcting things at the Florida legislature and your calls. Thank you so much.
Sure.
All right, who else we got, Rob?
Let's go to Donna from Newport.
Donna, how are you?
Newport Richie?
I'm good. How are you today?
Okay, where are you calling from? Newport Richie. Okay, how can we help you?
Okay, so we just had an election for our HOA.
Yes.
And I had a couple questions. The first thing was our bylaws don't have any qualifications to run for the board.
Okay.
However, the election committee decided to disqualify a candidate. What they did to make up for the deficiency in the bylaws, which they changed last year into a word salad, was to have a candidate nomination form. And on the candidate nomination form, they ask the candidate, they have the candidate swear that they are listed as the owner of the home in the association on the county appraiser's website. So this woman tried to run for the board, and she's listed as the owner on the record of the county. But when you pull up the deed, the property is listed as Mr. John Smith, a married man, which under Florida law, I guess if you're a married man, your wife owns half your property when you go to sell it.
Not true.
So this,
Rob, women love
this
to think that
election-
way. I get half. But I get half. No.
I get half. No, I get 3/4. You get what's left.
Eddie, I want
Hey,
half.
remember Eddie Murphy?
Yeah.
Right?
Eddie.
Last week you're riding the zebra and Tony.
This election committee,
bone.
which incidentally has a member on it that is not even a member of the community, which defined in
Okay.
the bylaws
I
is
just
an owner.
hold on one
They
second.
decide to disqualify her.
I just had this conversation with somebody like in the last 2 days. I don't remember speaking about. I think what was it my wife or my daughter? I think with Brandon. No, I had it with Brandon. So it happens a lot where, and it happened to me about 2 months ago, where a woman came into my office and issue came up about running for the board, and let's just say sometimes people are very, very alarmed to learn, right, that I don't own my property. What do you mean I don't own my property?
Oh, she wants to
The
run for the board.
property
She's not
was
on the
bought
deed.
30 years ago in your husband's name, and it's still in your husband's name, or vice versa. This kind of stuff happens all the time. And sometimes it really results in a problem. I mean, people, they find out, like, my husband never put me on the name, on the deed. Wow, and, and World War III could start, believe me. In this situation,
How am I not? I've been paying half.
if the bylaws say that you have to be a member of the community in order to run, and a member
No,
is...
it doesn't even say that. Doesn't even say that.
Okay, so if it doesn't say that, then maybe there's an argument that she can run. But let me keep going on this my way for a second. If the bylaws say that you have to be an owner to run for the board, because only owners can be members, and members are the only one that's allowed to run. So it's common, believe me, it's more common than you think, for a spouse who's been living in the community 20, 30 years, and you do a check, wait a minute, is this person an owner? Holy cow, they're not an owner. They live here for 30 years, but they're not an owner. Their spouse is the owner.
They probably argue with you.
Yeah.
Oh.
Guess what? You can't run for the board. So, what else?
Okay, so if the deed,
Yes.
the deed says a married man,
means nothing.
it means nothing.
Correct.
Okay.
Correct.
So they did file another quitclaim deed and added her onto the property.
Okay.
But the election committee decided that because she was not an owner of the date that she filed her candidacy form, she was disqualified.
And that, depending upon what your documents, that could absolutely be correct.
Okay.
If there was a deadline to submit your name, and by that deadline she was not an owner, then that board is absolutely correct. They did nothing wrong.
Okay.
Okay? And this
so
happens.
So
you know,
the requirements on the candidacy form, they're not in the bylaws. They're valid.
Understand, I'd have to read the bylaws to figure out whether or not that was the appropriate decision here. But other than that, you have, if you've been convicted of a felony and your civil rights haven't been restored for the last 5 years, one reason to make sure you can't run, right? So this person wasn't convicted of a felony, right? So we move on to another reason why she can't be.
But you don't have to live in the
disqualified.
country.
You don't have to live in the country. You meet anywhere in the world and still run for your board as long as you're the owner, right? Were they delinquent on the day that was the last possible date to submit your name to be a candidate? If you owed any money to the association, then you can't be on the board as well. Can't run either.
Even $30.
Even $30 can't run for the board, right? So again, felony, being delinquent, can't run for the board, and most of the time the documents say you have to be a member. If yours don't say it, okay, maybe you don't have to be a member, and maybe she had the right to run.
What if it was a felony and you were never sentenced?
Donald, I'm sure, doesn't want to be on the board of directors. I'll guarantee it. He has enough on his plate. So I hope that answers your question. If you'd like, call us.
I did have one more quick.
Got to go to a break.
Question.
Yes.
Quick. Okay. At the in-person voting,
yes,
the ballots were to be placed in an envelope marked ballot, and that was supposed to go into another envelope marked with your signature on it.
Yes.
They had the people that showed up for in-person voting take the ballot out of the signed envelope and just put the envelope marked ballot into the ballot box, and then they disqualified them all.
That's wrong. Did they sign the exterior of that little envelope?
Nope, didn't, because it says don't put anything on it. So they didn't. They had their ballot in that. There was the ballot, and the ballot envelope, and then they went into white envelopes where you signed.
Right.
When people showed up with their ballots, they said take them out of the signed envelope and put them in the ballot box.
And then they didn't count them?
And then when they went to count the ballots, they disqualified them.
Yeah, that's awful. Maybe that might be grounds for a challenge to a new election. It depends how many people that happened to and what the final results of the election were.
If it made a difference.
Yeah, would it have made a difference? And if it did, there's a chance of getting a new election. That's all I can tell you on that. We got to take another break. Sorry, Newport Richie. We got to keep the calls coming. You got it, 717-452-9378, or drop us a question in the chat box. Back after this.
In South Florida, the transition from bright sunshine to heavy rain and hurricanes can take a toll on your property's exterior and structural integrity. Cracked stucco, spalled concrete, they're more than eyesores. They can signal deeper issues. Now, with new Florida laws involving structural integrity requirements, we want to help you meet your milestone inspections and maintain the durability and beauty of your building. Since 2004, PD has been the trusted expert in structural concrete restoration, painting, and waterproofing for condominiums and commercial properties. Visit pd-concrete.com or call us today.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
All right, welcome back to the final segment of Condo Craze and HOAs here on our YouTube channel. We've got several callers waiting. You want to get to that first? Or
Absolutely, let's do that.
Our next caller is Linda from Boone Beach.
Boone.
Linda, how are you?
Hello.
I'm doing well. Thank you.
Where are you calling from?
I'm calling from Boynton Beach.
Oh, Boynton Beach. We may need to check the software, Robert.
Oh, man. So sorry.
Well, today you're from Boone Beach.
Boone Beach.
How can we help?
Boynton Beach. I wanted to say thank you for taking my call, and I wanted to say hello to a little doggy also. It's so darn cute.
That's Pippi.
And I am thankful for your show and your time today.
How nice is that? Really appreciate it. That was a wonderful comment. Thank you so much. And let me tell you, Karen, Rob, we're all thankful for all of you, believe me, who tune in. Thank you.
Okay.
How can we help?
Okay, I only know you have a little time left, but can you give me some advice on how I can help my condo association to move into implementing electronic voting so it will go smoothly and comply with the law? Basically, we need some help explaining the steps on how to serve both those who opt in as well as those who opt out.
Okay.
We want to prevent any problems. We want to move forward with electronic voting. We just don't know how to do it.
Okay, so the first thing that's required is a resolution by the board, right, adopting electronic voting for those who want to vote electronically. I will tell you that when that law came out allowing for electronic voting, I really didn't think it was going to work out too well. I thought it was subject to too much fraud. I thought the statute would potentially require too much technicalities in order to work. But I will tell you that over the last few years, those communities who have allowed for electronic voting had far more people participate in the voting of the community. It works out well. And I'm a fan of it now. That's what I can tell you. It took some convincing, but I'm convinced. Seems to be working. So how does it work? Again, the board has to opt into it. And when they opt into it, they have to hire a company, right, that does this for them. So in other words, how does it work? It's your annual election. You send out the first notice and you ask for who wants to run for the board. You get the notices of intent. Yeah, it is. So now the company that you hire for those people who wanted to opt in, so you'll give the people a form. If you want to opt in, sign this form, okay, and send it back, and we'll put you in for electronic voting. And then the company that you hire when it's election time, let's say they know the 5 people running for 3 spots. So they'll prepare a ballot that goes online.
Okay.
And because you opted in, the company has gotten in touch with you.
And you have an ID number.
You have a password,
Okay.
right, so nobody can hack your vote.
Okay.
And you'll log in, it'll show, okay, these are the 5, pick 3, all right, and you can pick 3 online, send it to the company. The company has those results waiting for me, let's say, when I go to the annual meeting.
But anytime anything's online, it's hackable. Because
It is
our
hackable.
U.S. our elections are not online.
Right, that's correct. Can't fight with that. Is it hackable? I guess anything is hackable. The only thing I will tell you is I've never been involved in a challenge to it. Like no one's ever come to me and say, I know that electronic vote is impossible.
But the guy that blew up the car 20 years ago might hack it.
Right, maybe. But I've never been told that, hey, the electronic voting system in this condo is obviously flawed, it's a fake, and here's why. Never heard that. I've only heard positive things. So I'll go to the election that night. I'll make sure that a person did not vote electronically and by paper ballot, right? We got to make sure that that didn't happen. If they did,
twice.
yeah, if they did, I can't count, either one.
Really?
But then at the end,
Even if they voted the same way?
Don't know how they voted. You can't count them if they voted twice. So
it's a blind ballot.
Yeah. Or the board can make their own resolution that say, if you voted twice, we'll only count the one that was done by mail, or only count, it's got to be one or the other, obviously. Or if they say nothing about it in their resolution, then the bottom line is I'm not counting either one of them. Okay. But again, a resolution is done. I get to the meeting. I make sure the person didn't vote twice, right, both ways. And I do the paper ballots first, and then I say, okay, here's my numbers. I add it to the person from the company is there that night. I ask for their numbers. I take their numbers. I add it to my numbers, and may the best man win. That's how it works. I think it gets more people involved in the process. I mean, just think if everybody was allowed to vote, on major elections that way, you'd probably have a lot more participation too.
Of course.
Yeah.
But then there's a question, not everyone has a computer.
Right. But here's what it's not, and people get confused. It's not the same thing as voting by email.
Right.
Voting by email is not the same. You cannot vote by email. This is a very specific process being done by a very specific organization, a very specific company that puts together this for you in a complicated fashion, quite frankly, sends it out to you and gives you the right to vote by email. But it's not like the elections today, and you can send an email to the manager, hey, cast my vote for Joe Smith. That doesn't work that way. Much more complicated system. But for me, yes, so far I think it works. I'm a fan. Okay?
Thank you very much, Eric.
You got it.
For your time. Thank you.
Okay. Who else we got, Rob?
Let's go to Dale. Looks like Park Village Condo Association.
How are you, Dale?
I'm good. How are you?
Okay. How can we help?
Okay. So last year, our property manager recruited people to get on the board.
Okay.
And she recruited some people that were her quote unquote buddies. And now nothing has been done the entire year. And I know that can't be legal. And I know she's doing it again this year because she's trying to get myself and somebody else that's on the board that are giving her a hard time off the board.
Okay.
What do I do?
So managers should not be involved in recruiting anybody for the board. Period. Bottom line, that's not their job. Their job is to manage the community. Their job isn't to help create a board that they think would be beneficial to the management
They're
company.
supposed to listen to the board.
Exactly. Not involve itself in an election. And there's actually a case. There's an arbitration case that says so.
Go ahead.
No. I just was saying there's actually an arbitration case that says that a manager should not be involved in the outcome of the election. They shouldn't be recruiting their own candidates. They shouldn't be advising you who they think is a better candidate. Hands off when it comes to the election process, other than preparing the documents. That's it.
Okay. So what she did was she recruited some people, and then she called a lot of people in the community and told them that certain people were going to come and pick up their votes.
Okay.
Now, I don't even start me. I've already turned her into the DBPR.
Okay.
So you said there's an arbitration case. Is this something I can look up and present because we're about to have an election at the end of January?
Probably not, unless you subscribe to Westlaw, which I'm sure you don't. So no, you can't. But send me an email and I'll try to find that case for you. Okay?
Okay. What's the email address?
Eric at condo-laws.com. Okay, Eric at condo-laws.com. Thank you so much for the call.
Thank you.
Keep going, Rob.
Next caller is Barry from West Palm Beach.
Barry, how are you?
Larry, Terry,
Anything close?
Gary.
All right, next call.
Let's head over to Tampa. We have Sam.
Sam.
Sam in Tampa. How are you, Sam? Sam, are you there? Okay, let's give it one more shot.
All right, let's see. Leslie.
Anybody? Leslie.
Going once.
Hi.
Oh.
Hey,
Hi, how are you?
Who do we got?
I'm thankful for you guys.
Thank you, Leslie.
Hello?
Yes, thank you so much for calling, Leslie. I know exactly who this is.
Okay.
What happened
Leslie, I can't hear you on that speakerphone, though. I can't hear you on a speakerphone.
closer
It's
to the
impossible. Let me say one thing about Leslie, okay? Leslie is on a board in Palm Beach County, okay? Leslie is disabled.
Okay.
Leslie can't walk, and Leslie basically lives her life in a wheelchair. Maybe she can walk a little bit. I don't know. The only time I've ever seen Leslie is when she's in a wheelchair. And if I tell you that she makes an effort to come to every board member education class that I've ever taught in that county, I'm sorry, she's an inspiration. She's unbelievable.
Yeah.
So if she can come to an
No
educational
excuses.
class, I don't want to hear from about anyone else that it's a hassle. Leslie makes it, and it's the most difficult for her. Okay?
Right.
So Leslie, thank you. I'm thankful for you this Thanksgiving. Okay, Leslie, unfortunately, we can't hear you, honey. We can't hear you, so I'm gonna have to move on to a different call. I'm sorry, but I want to thank you for being a loyal listener and a loyal education attender, if that's the word. She's fantastic. Hey, thanks, Leslie. But had a happy Thanksgiving to you. Let's move on to the next caller, Ron. Can you let us know when we're out of calls, and we'll wrap it up.
We have a few more. So we have Barry from West Palm Beach.
Barry, you're back. 5, 4, 3, 2, 1. Barry, next.
Nope, Barry's gone. All right, Eric. Oh, we have an Eric.
Must be a bright guy.
Oh,
Good looking too. How are you, Eric?
I'm doing good, and you?
Okay, how can we help?
Okay, my father passed away. He was the owner of the condo in the association that we lived together at. And he left a ladybird deed, leaving me the condo.
Yes.
is there a specific time that I can just leave the estate or the condo in his name, or do I have to transfer it in my name?
It's in your name automatically now. Okay, it is in your name. The minute that he passed away, it is in your name. But in order to protect yourself, if it comes time that you want to sell that property, what you should do is record an original death certificate in the county where your property is located, and that death certificate will put the world on notice that your father passed away, and you look at the deed that your father owned it in, and it will show that it was a ladybird deed. A ladybird deed is, excuse me, some states call it a ladybird deed, some states call it a life estate deed. It's one and the same. I call it a life estate deed. It means that while his father was alive, it was his father's unit, right? And automatically upon passing, however, it shall go to my son. Okay, so the house, the apartment, the condo doesn't have to go through the probate process.
Right.
I would encourage anybody out there who owns a unit, who owns a home, who owns a condo unit, whatever it is, if you want to make sure that that unit doesn't have to go through the whole damn long probate process when you pass, do that ladybird deed now. Do a quitclaim deed now. That means when you pass, and believe it or not, you will pass at some point, right? It automatically goes to your child with nothing else to do other than record the death certificate in the county. So that's what you should be doing, okay?
Okay, yeah, because when I filed the ladybird deed with my father, the clerk told me I had to walk in with his death certificate, and then it'd be in my name.
There you go. Okay, so like I said, record a copy of that death certificate, and then automatically, yep, it's yours. I'm telling you now, even without recording the death certificate, now it's in your name. I mean, your father passed, but record the death certificate. Be safe.
And when you say
correct.
record it, just
go to the clerk's office, the recorder's office in the county where the property is located. Say, I want to file this death certificate in the county records.
Okay.
They will do it for you. Maybe cost $10 or so, and then you won't have a problem at some point if you wanted to sell it.
Okay.
Or remain in it according to your board of directors. Okay?
Okay.
All right.
All right,
So
thank you, sir.
You got it. Me and the clerk agree. What do we got, Rob?
It looks like Mo. I think it's Mo. Coconut Creek.
Hey, Mo. You're
Hello,
next.
Eric. How you doing?
Yes. How can we help, Mo?
Okay. Where can a board get instruction of how to increase the number of board members from 7 to the current 5 members?
Ask the question again. How can the board do that?
We would like to increase the number of
Okay, you'd like
board
to
members.
increase it. Okay. Now
From
I don't
5
know
to
what your documents say. What do you know exactly what your documents
That's
say?
what he wants to know, where to find it.
Where do you find it? You want to look in your bylaws. The bylaws will tell you
The bylaw says 3.
no less than
or
3,
more.
no more than 7, something like that.
No, it doesn't say more than 7. It doesn't say that. It said 3 or more.
3 or more. Okay. Does it say
Sure.
anywhere that how you decide from year to year what the number is? Okay. Does it say how you arrive at the number each year?
They've been working with 5 for the past 12 years.
Well, if it says nothing, it's 5,
Yeah,
right?
bingo, Karen. Karen hit it on the head. So, here's Florida law. If your bylaws say, like this is very common, you cannot have less than 3 nor more than 7, less than 3 no more than 9. Like when it gives a range, if it doesn't tell you how do you figure out that range each year, what's the procedure, then the number is automatically 5.
Now, can they do 7 if they want to?
If it says at least 3, but there's no mechanism as how you decide from year to year,
Yeah.
it's 5 in his community as well. Right? So the bottom line is there a mechanism when there is a range, your documents call for a range, no less than X, no more than Y. It gives a range, very common. But you can't figure out year to year, how do you get to the number? The number is automatically 5 in a condo.
But if he wants 7 to run, they can.
If
we want
7
7,
people
yeah.
could run,
Yeah, that's what he
but
wants.
it doesn't mean the board can be 7. The board has to be 5
Well, how
if
can
you're in
they
a condo.
get it to 7?
Amend the bylaws. If you want to increase the board for sure and for certain, you're gonna have to take a vote of the community to amend your bylaws.
Even if there's a thing that says 3 to whatever?
Correct. If there's no procedure on how you get there from year to year, and it's confusing. How do we decide this year? Then automatically the number is 5 in a condo. Okay.
Darn it.
Who else we got, Rob?
Thank you.
Anybody else?
Yep. Let's go to. Oh, hang on. Sam.
Sam is back. How are you, Sam?
I think it's Sam.
Yes, I'm sorry you didn't get my call. I had a volume problem.
No
I have
problem.
a question regarding the budget. Can you hear me?
Yes, we hear you.
Okay. We're doing the budget, and all of a sudden the treasurer wants to have a 6-month budget for 2025. This is due to our location. We're on the beach in Pinellas County, and we had water search, and our building is unsafe. And I have suggested that we and we have no water, no electric. There's hardly any services. This affected 8 units out of 12, and I am opposed to a 6-month budget. It's illegal. Our document says fiscal, January through December, and I'm telling you it has to be fully funded. And our placard says on the building, unsafe. We've done the remediation. We have the insurance from FEMA.
Hold on one second.
In regards to our claim.
Were you ordered
and,
out?
they've
Hold
already
on.
removed 4 feet.
Okay, hold on. Is the building closed? Were you ordered out by the building official?
Yes, there's a placard, unsafe.
Okay, so here's the law in a nutshell. The budget has to be an annual budget. I agree with you. Okay, no such thing as doing a short-term budget. Your association must adopt an annual budget,
But
not
this
a
sounds like it's a
6-month
hurricane
budget.
problem that FEMA needs to
So-
pay for. They don't have to reserve for that.
Here's what the law has now allowed for. In those situations where you said there's mandatory reserves, like in your building, the law now says there's an exception. You don't have to fund those, right? You don't have to fund those mandatory reserves if the building official has closed the building, and the unit owners get together and a majority of you want to waive the reserves going forward. Yes, you can waive those reserves. It's a brand new provision in the statute, became effective in July.
Interesting.
So a majority of you now can say no reserves, but absolutely you need an annual budget. You're right about that. Okay? A 6-month budget to me would be illegal.
Our situation is right now is that the remediation has been done. We're waiting for the permitting from the municipality, from the officials, so we can proceed with the so-called white box repairs.
Where are you
That's
located,
where we're
by
at.
the way?
Pinellas.
Pinellas
Tampa.
County, yeah, West Coast.
What hurricane?
North Reddington Beach. North
Gotcha.
Reddington Beach, and this was Helene.
Helene got you, yeah, just recently.
Yeah. So FEMA's going
I
to
had
pay
3 feet of water in my apartment.
Wow.
Oh, man.
What terrible. The West Coast got it again
yeah.
this year. Yeah, amazing.
So they don't have to reserve for it.
So
FEMA
that-
will pay, right?
No. They still have to reserve. The FEMA will pay, or whoever their insurance company is,
Right.
will pay to make the repairs to the building. Sometimes that's not enough. Sometimes it's too much. We don't know yet. But now it's difficult to be on the board of directors.
Yeah.
Very difficult now.
Because you have to differentiate
a lot of
between the
decisions.
safety
Yeah.
concerns of the seers and the damage from the hurricane.
Correct. There's a lot of things that now the board has to consider. But one thing you can say is, okay, no more mandatory reserves. We can stop it if half of the people agree. Why? Because the new statute says you can do that when the building official kicks everybody out.
But also, you don't have mandatory reserves till 2026 anyway.
If you vote against it, if you vote it down this year,
Yeah.
yes, you can do that.
You can vote it down.
Yes, that's true. Okay.
And Eric, our building is 2 stories. I'm in a
so
2-story
no
building,
mandatory reserves.
and then the
anywhere.
other is a 1-story.
Okay.
So
And it
what
doesn't
you're
have
saying is
Kaufman.
that we can vote to waive the reserve.
Yes, you can.
Still continue on the annual budget, such as paying the premiums. We still want to continue having insurance.
You
so
better do that.
Those premiums need to be fully funded.
And I'll say this. In a situation like yours, okay, where you have obviously suffered devastation to the property, obviously.
8 feet of water.
Yeah, I mean, there's going to be a lot of things that your board has to do going forward. I mean, these are massive now rebuilds that you're going to have to do. And
Correct.
I don't know what you do for a living or what everybody else does on the board for a living. You might want to hire someone to be a project manager, not just, construction. Maybe
we
not
have that. We
Good.
Have a public,
do?
We have a public adjuster and a contractor.
And what's the white
an
box
adjuster's
thing?
different. I'm talking about a project manager. At some point, you're going to sign contracts with contractors to rebuild the place, right? And there's going to be a lot of stuff
Well, it's
going
all
on.
done except for the white box stuff, and he's waiting for you're waiting for the city to give you your permits?
Yes.
Yeah, but who's going to make sure
All
that
along the
what
coast.
was promised to be done gets done? So did you sign contracts already with contractors?
The board has with the contractor.
Yeah, I hope those were reviewed by council.
They've done that with the remediation.
All right, what I'm
remediation
suggesting
has been done with 4 feet of drywall.
I hear you. What I'm
Now we're
suggesting
ready-
in
now-
general is that these are difficult projects.
Yeah.
People have their own lives. People go to work every day and
No,
whatever
you
they
need
may
someone
do.
overseeing it.
I mean, you really
It's
need somebody
self-managed.
there to make
12
sure that.
units, self-managed, no management company.
Yeah, no, well, that's so now there's not even a management company watching what people do. I think you,
Yes.
at a minimum, should have a project manager because it's very difficult for you guys that have lives to make sure the contractor's doing the right thing, that it's going in according to time schedule, the right materials are being used, etc. And that's what a project manager is
And what's
for.
the white
They're
box?
independent.
What's the white box thing you were talking about?
The white box is to put it back to where it was before the storm.
Right.
Okay.
Well, again, I'm just
Okay.
suggesting that you get help, okay, by getting a project manager. Thanks for
Thank
the
you,
call.
Eric,
Appreciate it.
very
Anybody
much.
else? We'll make this the last one of the day.
And that is the last call.
And that is the last call. Okay, great.
Let's see. We'll give Barry from West Palm Beach one more time.
How many Barrys and Larrys are there? It's the whole day I'm repeating
And
the
we had a
same name.
Mo.
I think
Hello?
we should try-
Yeah, we
we have Barry.
Yes.
Hello.
How are you doing?
Okay, who do we got?
This is Barry McManus,
Okay, Barry, where are you from?
West Palm Beach, Florida.
Okay, how can we help?
I was just wondering, on the new laws, when you see all the financials, when I call up the property manager and ask for all the financials, he never gives me, I ask him for who's delinquent, and he says that he can't give it to me because I'm not on the board, but that's not all the financials.
Obviously
right?
wrong. Okay, but you shouldn't be calling the property manager. If you want access to records, you shouldn't be calling. Okay, the way these your rights kick in and responsibilities kick in on behalf of the association is if you're in a condo.
Well,
you
I
have to-
usually text him.
Oh, okay. Well, again, I would send it for well, if they respond to your text, then I would say yes, that's fine. But if they do, and they tell you they're in the process of getting it, they're they're working towards gathering them for you, then you're fine. But I would always ask for the records, a certified mail return receipt requested. That's proof that they got it. Suppose your email is ignored. Now you got to prove that they got it and they read it. So I would send it again,
Right.
certified mail return receipt.
How do you
And-
prove that?
You know, I didn't
Pardon?
know this until about a few years ago. You can send an email, and there's
But
hold
they're
on a
supposed
second.
to give me
Hold
the
on, buddy. Hold
delinquent,
on.
correct?
Hang on, Barry.
Hold on, Barry. And you can send an email and send it with, you click certain buttons, and you know when the person got it, and you know when the person read it.
Okay.
Yeah, read receipt it's called, right,
Okay.
Rob?
That's right.
Yeah. So
Okay.
yeah, that I learned too. That's a way of protecting yourself.
So,
What-
so the guy that sent the email telling the board there was a safety issue with the gate,
Yes.
he needs to have those buttons
A read
clicked.
receipt. Yes. So you can show via
they
a
read
read
it.
receipt. Yeah, that they've read it. So yeah, absolutely.
Okay, Barry,
what
sorry.
was the end of that question? Did we answer your question?
So they do have to give me who's in the rears.
No, okay. That's an interesting question. They don't have to make a list for you of anything.
A
Period.
delinquent
They don't
list
have
is
to
a bad
create
idea.
a document for you. They only have to give you copies of documents that that already exists. So you can say, "I'd like access to all of the account ledgers for everybody in the community," and you can go in and see those account ledgers.
I mean, they can't make a delinquent list, can they?
And they can't publish that
And they
delinquent.
publish.
If they have a delinquent list and it's something they use routinely, then yes, that's considered certainly an official record of the association. But they don't have to create a document for you that just because you asked for it, they have to create it. No such thing. If the document exists, a list of the people in arrears, then yes, you can get it. Okay?
And that applies to unapproved budgets, too.
That applies to unapproved budgets as well.
As I've learned the hard way.
It sure does. You got it, buddy.
Really?
I'm trying to purchase a property, and I know that there's a new budget coming. It just hasn't been approved yet.
But you still have access to it.
I'm not entitled to it because it hasn't been approved, nor is it
to be approved.
And
created.
yeah, Rob and I are working together on something this week, and we're going to do a show on this topic because to me it's so important.
Yeah.
The topic is going to be, okay, you want to buy into a condo now. You want to know everything about your reserves, how much money is in the bank.
Yeah,
did you do your 30, 40, 50-year study? Did you pass? Is it still ongoing? And most importantly, are there going to be special assessments coming up? And you may be surprised to learn the answer. We're going to hold you right there because we're going to do a whole show on that. What must the seller disclose? What must the condo advise you of if you're about to buy a unit? We'll do a whole show on that, okay? But that brings us to the end of this show. Didn't it feel good being back Sundays?
Yes.
I love Sunday mornings. Rob, Karen, thank you both for coming on a Sunday morning. I know it takes time away from everybody's personal life, families, but I think we all are happy here. I think we like doing this on Sundays. I know I am. I can tell you
over
that.
100 people watching.
Yeah, the attendance was great today. So I want to thank all of you. And as one of our listeners chimed in and suggested she was thankful for us, I am thankful for all of you.
Thank you.
I'm thankful for both of you guys
yeah.
as well. Thanks for everything you do each week for the show, as a matter of fact, and our listeners as well. So what do I wish you? A happy, safe, fun, healthy Thanksgiving with you and your families. And we will see you again next Sunday on Condo Craze and HOAs, back on Sundays at 11 a.m. Everybody have a wonderful week. Enjoy.
Thanks, Eric.